Good evening. My name is Danielle Dart, and I coordinate public programs for the Minnesota Historical Society. Welcome to the History Forum. This season, we are exploring a handful of the currents that have shaped the United States and that complicate its national motto, E pluribus unum, which means out of many, one. Tonight, we join Professor Bruce Duthu of Dartmouth College to explore the subject of Native sovereignty and the history of U.S. tribal relations. The United States, like every human community, owes its existence and vitality to the generations of people who contributed their hopes, dreams, and energy to its making. Some were brought here against their will, some were drawn to leave their distant homes in hope of a better life, and some have always been here. We acknowledge that Minnesota is located in the traditional homelands of the Dakota people and the historical territories of the Ojibwe and Ho-Chunk people, that 11 sovereign nations exist within its borders, and that it is home to the largest and most diverse urban Indigenous community in the country. We pay respects to the many Indigenous elders, past and present. We pause to consider the many legacies of violence, displacement, migration, and settlement that bring us together here tonight. And we invite all of you to join us in exploring and discussing the complicated truths of our collective past. When the United States achieved its independence from Britain, there were already hundreds of independent sovereign tribal nations on this continent. Article 1, Section 8 of the US Constitution, which grants these nations the same status as foreign countries and the states, recognizes the existence of a pluralistic system comprised of three coexisting governments: federal, state, and tribal. Yet the history of US tribal relations since that time has followed a trajectory aimed at the erosion of pluralism and of Native sovereignty. How might knowing this history help us develop a shared understanding of the importance of Native sovereignty and find new ways to envision the promise and potential strength of a truly pluralistic United States? Our speaker, Bruce Duthu, is the Sampson Occam Professor of Native American Studies at Dartmouth College, an internationally recognized scholar of Native American law and policy. Duthu is the author of Shadow Nations, Tribal Sovereignty and the Limits of Legal Pluralism, and American Indians and the Law, and was a contributing author to Felix S. Cohen's Handbook of Federal Indian Law, the leading treatise in the field. He previously served as professor of law at Vermont Law School and as visiting professor of law at Harvard Law School and at institutions in Australia and Italy. He is a member of the United Homa Nation of Louisiana. Please welcome him to the History Forum.
Thank you very much, Danielle. I also want to give thanks to the Minnesota Historical Society, to Danielle in particular, and Ned for his technical assistance. I also want to extend greetings from Vermont. I live here in White River Junction. We are on the western end of the Wabanaki Confederacy lands. This is a homeland of the Abenaki people, and my family and I have been blessed to live here since the mid-'80s, since I've been working both at Dartmouth College, at Vermont Law School, and then back at Dartmouth College. I want to thank you all for joining us. We have so much that's been going on in our country, and I just am so grateful that you would all take the time to join us to discuss, along the lines of the themes of E pluribus unum, the connections and relevance of the experiences of the tribal nations in the US. I've given this title, Tribal Nations, the State, and Legal Pluralism, because I want to focus on what I'm calling the judicial manufacturing of historical facts. As Danielle laid out in her introduction, in my book, Shadow Nations, I talk about the formative moment, the early American period, and the Constitution's acknowledgement of the pre-existing sovereigns who lived and operated and governed on these lands for many, many generations before the arrival of Europeans. And my central concern in Shadow Nations was to examine the reasons, the multiple reasons for the erosion of what I call the ethos of legal pluralism that the Constitution embodied. This idea that you could have multiple legal systems coexisting on shared territories, learning from each other, adapting and accommodating each other, and living in relative peace. We're going to focus particularly on the Supreme Court. One of the interesting things that we've examined over time is that while the Congress of the US, largely under its constitutional powers, organized relations with the tribal nations in ways that proved to be quite devastating to them, and the Supreme Court occasionally departed from that narrative. In the modern era, and by modern, I mean in the period of self-determination from the 1970s to the modern era, the Congress has been largely supportive of tribal sovereignty, and we see that the Supreme Court has been the branch of the federal government that has been most problematic for tribes. That is not to say that we are not still hampered by the legacy of earlier statutes, broken treaties, and judicial opinions. So when we talk about the erosion of our moving away from this ethos of legal pluralism, how exactly has the court done this? What I want to suggest in this talk is that the court has done this in large part by its production of historical facts about Native peoples and their sovereign status here in the US. In short, they've done it through storytelling about our nation and our nation building project over the generations. I thought I'd start with a Minnesota connection. Many of you may know this powerful novel by Louise Erdrich, a classmate from Dartmouth, The Roundhouse, which deals with the pernicious problem of sexual violence against Native women in Indian country. In a passage in this novel, Louise has a scene where one of the two of the main characters, a father and son, are having a conversation about law, about federal law that applies in Indian country, particularly criminal law. And the father, who is a tribal judge, uses a rotten casserole to illustrate a lesson in the legacy of federal Indian law. And notice what this passage says. This is the judge speaking to the son as he's describing a legacy of different Supreme Court opinions. And he says, this is the one I'd abolish right this minute if I had the power of a movie shaman. Oliphant versus Suquamish. It took from us the right to prosecute non-Indians who commit crimes on our land. Now, we're going to use Oliphant as our judicial guide and frame for a number of reasons that I hope to make clear as we go through the discussion. This is where the Suquamish people live and reside. If you see Seattle kind of in the right there, across the Sound is a very small community, Port Gamble, Sklallam, and just beneath that, Suquamish. The author of the Oliphant decision, so our storyteller in chief for the next several minutes, is the former Associate Justice and then later Chief Justice of the US Supreme Court, William Rehnquist. He was the author of the majority opinion in this case. And in brief, as the excerpt from The Roundhouse suggests, this case had to do with a very fundamental question. In 1978, do Indian tribes, as an exercise of their sovereign authority, do they have the power to prosecute non-natives who commit crimes against tribal law, who break a tribal law? And the court's answer was no. That's the easy part about that case. Probably the only easy part of that case, because it's known, renowned, or infamous, depending on one's perspective, for its rationale, its storytelling. Because here's the court in 1978 having to decide a question that many people would have thought had been resolved generations earlier, but it wasn't. So to guide us through Oliphant, obviously I'm going to give you the abbreviated presentation of the case. To talk about storytelling, to talk about what I'm contending here is the judicial manufacturing of historical facts. I'm going to use three rubrics, three framing themes to work our way through the Oliphant case. The first theme is this notion of incorporation. It's a term of art that the court uses in this opinion, and it takes us back in time. So each of these framing rubrics will allow us to do what the court does, which is to take us back in time and see where does that concept evolve? Where did it first begin? What did it mean? And what meaning is it given today? So the first rubric framing is incorporation. Then we'll take a brief look at the notion of submission or consent. In other words, that the court will maintain that the tribes consented to this arrangement of political relations between themselves and the federal government. And the last rubric is the very notion of sovereignty, contestations over who counts as a sovereign. So let's take a brief look at this first theme of incorporation. And here you see a very broad map without details, but just the darkened portions are the contemporary spots, the residual areas of tribal lands, Indian country. And you see it's predominantly in the West, although there are pockets of Indian country throughout the US. Well, here's the passage from Oliphant that uses and references this notion of incorporation. Now, I should give you a forewarning that some of the slides are going to be text heavy. I'm going to give you some time to digest some of the language, but I'm really just going to focus on some of the terms that the slides pick up. And here the word incorporation comes up very early. Upon incorporation into the territory of the US, upon incorporation. You know, you just look at those two terms and it may evoke different things for different people, but one of the things it might suggest is that there was a particular moment in time when tribes became incorporated into the US. But for those of you who know a bit about the American history, you know that there wasn't one moment in history where tribes were incorporated. The US simply didn't evolve in that way. In fact, if you look at this slide, you'll see, now don't hold me to the particular dates here, but at least in a broad strokes, you see that the US accumulated huge parcels of land over time, beginning with the 13 colonies and moving west, and ultimately ending with Alaska and Hawaii to form the present 50 states. So this took place over a matter of time and in very, very different circumstances. Wars, treaties, purchases, battles with other sovereign nations, laying claims to these lands, etc. So upon incorporation simplifies an awfully complicated record. Where does Justice Rehnquist get this notion? What is he alluding to when he talks about upon incorporation? Well, he takes us back to the very first case decided by the US Supreme Court that really spoke clearly about tribal nations' connections to their ancestral homelands. And the case is called Johnson against McIntosh. And again, a lot of text here, but the nutshell version of this case is it really answered the question, what is the legal claim that Native peoples have to their homelands? And do they have the power to convey title to those lands to third parties? In other words, can they sell their land? This was a land dispute. And the court uses this European doctrine called the doctrine of discovery to answer that no, in fact, tribes were not the owners of their homelands, that in fact, their legal claim, their title to their own homelands was more akin to the rights of an occupant, kind of like if you're leasing an apartment from someone who owns the building. And this is what the court says the tribes have in terms of their title. Notice the middle of portion of this passage where the court references the character and religion of its inhabitants afforded an apology for considering them as a people over whom the superior genius of Europe might claim an ascendancy. Now remember, I started with a 1978 opinion by the US Supreme Court, and early on in the opinion, we're taken all the way back to this early opinion from 1823. So something about the character and the religion, tribes as, what does that mean? Well, look at this next slide. The court gives us a little bit more specificity in terms of its characterization of Native peoples. The tribes of Indians inhabiting this country were fierce savages whose occupation was war and whose subsistence was drawn chiefly from the forests. To leave them in possession of their country was to leave the country a wilderness. Now, there's a lot to unpack there, and my students and I will usually take an entire class period to digest a passage like this. There's so much going on here, but I want to draw your attention to this reference to the tribes whose subsistence was drawn chiefly from the forest. There are other references in this case, Johnson against McIntosh, that characterizes tribes as hunters and gatherers, essentially primitive societies. And I would contend that that's one of the first instances of a judicial manufacturing of a historical fact. And I would put fact in quotation marks here, because this was written by Chief Justice John Marshall, a Virginian. Marshall, of all people, would have known his history, that the tribes, many of the tribes along the eastern seaboard, certainly were hunters, but many of them were also accomplished agriculturalists with extensive farmlands that actually played a big part in allowing the formative US to begin, the formative colonies, and later the US. So this is at best an incomplete vision. Why would the court give us this narrative, fabricate, produce a description of tribes that they were essentially hunters and gatherers? There are a lot of reasons. One reason might be that if the court characterizes tribes as hunter-gatherers, as savages, as primitive peoples, that it would be near impossible for them to make a legal argument that they were also able to employ the sort of Lockean theory of enmeshing their labor with the land in order to produce property rights that the US would have to recognize. By characterizing them as hunters and gatherers, as fierce savages, the court is effectively taking tribes out of that orbit of peoples who can, through their labor, produce property interests through the use of their lands through things like agriculture. And so that's a very significant production, if you will, of a historical fact, which we know is not true. And yet there are other instances in the opinion, we're not able to go into those details, where the court seems to know that it's playing fast and loose with the true historical facts. There's a sense of moral ambivalence about the correctness of this decision that Marshall leaves throughout. Let me leave that there and move to our second rubric or frame, this notion of submitting, the idea that tribes, this is a portrait, actually, a photograph of the Fort Laramie treaty setting of 1868. And take us back to Oliphant. So I'm taking you back to 1978. And notice in this passage, the court says, by submitting to the overriding sovereignty of the US, tribes necessarily give up their power to try non-Indians, except in a manner acceptable to Congress. By submitting to the overriding, there's a notion, the way that the court crafts and uses this language here makes it sound like this was entirely voluntary, consensual. There's a presumed consentience that the court is working on here, that this is agreeable with the tribes. Now, the court is writing this, Rehnquist is writing this in 1978, and just as with the previous passage, he takes us back in time. In other words, he locates this kind of phenomena with a precedent, or sometimes a number of precedents. What is his precedent for this language? Well, it's a case from 1903, Lone Wolf versus Hitchcock. This is a case in which the US Supreme Court essentially held that Congress possesses the power unilaterally to break treaties with Indian tribes. That is still good law today. The court has never moved away from that position. There are other bits of the Lone Wolf versus Hitchcock decision that have been modified, if not outright overruled, but its fundamental holding that Congress can abrogate treaties with tribes unilaterally is still good law. In fact, some of you may know, just last summer, July of 2020, the US Supreme Court decided a case called McGirt versus Oklahoma, in which they cite the Lone Wolf versus Hitchcock and says, look, we know that, the Muskogee Creek, like all tribes, had treaties, or most tribes had treaties, and we know that Congress can break the treaties. What we're looking for is evidence that Congress, in fact, elected to break the treaty. Look at this language here, this quote from Lone Wolf versus Hitchcock. When the treaties were entered into, it was never doubted. It was never doubted that the power, and the italics is in the original, not my highlighting. It was never doubted that the power to abrogate, to break, existed in Congress, and that in a contingency, such power would be availed of from considerations of government policy. In other words, Congress needs to be able to be nimble and flexible in light of new and evolving circumstances. But this idea that it was never doubted, again, where we have this idea where the court is giving us a notion of implied consent, that if look at that earlier photograph, that the Lakota and tribes, similar tribes, engaged in treaty making, went along with this proposition that, when the treaty commissioners went back to Washington, the Senate ratified the treaty, that Congress could unilaterally abrogate that, and the tribes would say, yeah, we understood that. I don't think so. So it's another instance of a manufactured fact that treaties, that the tribes had a sense that this was agreeable to them, that they understood that Congress could change its mind. The court never suggests whether or not the tribes reserve the power to abrogate treaties unilaterally on their part. Here's another important quote from the Lone Wolf case, where the court says, plenary power, plenary is a legal term essentially meaning absolute or uncontrolled. Plenary authority over the tribal relations of the Indians has been exercised by Congress, notice this next, from the beginning. It started out this way. Congress had this absolute control over tribal relations. And we just know that is not true. The tribes in the formative period of the American story oftentimes were the more powerful party. And that the government, as those of you who saw Professor Alan Taylor's first lecture in this series, there was nothing certain about the US's trajectory as a potential nation state and world power. There was a lot that was in the mix for the tribe as a future power. But notice the court here says that that power existed from the beginning. And notice the latter part of this passage. But as with treaties made with foreign nations, and then the court drops in this reference, the Chinese exclusion case is a very particular case they're citing here. The legislative power might pass laws in conflict with treaties made with the Indians. Well, in my earlier slide, notice that the court says that this power exists, but only in a contingency. And there's other kind of caveats, in an emergency, or when circumstances warrant. So there's all this, what I've called soft caveat language in Lone Wolf to say, yeah, that power exists, but Congress has got to have a pretty good reason for breaking its promises with Indian tribes. But nowhere in the Lone Wolf decision do we know what that reason was in that particular case. The Lone Wolf was a Kiowa man. And so the Kiowa, Arapaho, and Comanche tribes were trying to essentially stop the implementation of a disastrous federal policy that was essentially taking tribal lands and allotting them to allow for westward expansion for homesteaders to come in and lay claim to tribal lands. So there's no language, there's no passage in this opinion to say if it's true that this power can only be exercised if there is a suitable circumstance or exigency or contingency. What is it? And the only hint that the court gives us is this parenthetical reference to the Chinese exclusion case. If you were to read that case, you'll learn that this was the first instance of the court upholding the unilateral abrogation by Congress of an international treaty. There's a treaty with China to end immigration of Chinese nationals into the US. And the reason? Well, if you read the opinion, the court heard testimony, or there were testaments by people in California, the elected officials of California, at the latter part of the 19th century, saying, Congress has to stop this influx of Chinese nationals because we're being overrun. And the biggest concern was that the Chinese nationals, unlike European immigrants, were not assimilating. They were insisting in maintaining their communities, speaking their language, essentially living as Chinese people within the state of California. And by analogy, this is what the court is telling us was the exigency in this case, that the reason, the good reason, the contingency by which they could justify and excuse what Congress was doing here is that Native peoples, just like Chinese nationals, were not playing by the script. They were not assimilating. They were insisting on maintaining their indigeneity and not assimilating like they were expected to. Let me turn to the last rubric, the very notion of sovereignty and contestations over the tribe's claim to a sovereign status. And again, like I've done before, I want to start with a quote from Oliphant. And this is towards the opinion of the court's opinion in 1978. In this passage, you'll see that the court is actually quoting. So it is building on an earlier language from an opinion that I'll show you in just a second. The case is called U.S. versus Kagama. But notice what the court is highlighting. It's lifting from this case from the 1880s and plopping it into an opinion being written in 1978. In summary, the respondent's position, the tribe's position, ignores that, and here we're quoting the language from the 1880s, Indians are within the geographical limits of the US. The soil and people within these limits are under the political control of the government of the US or of the states. Notice this concluding passage. There exists in the broad domain of sovereignty, but these two. This is pretty profound. It's one thing for the the Supreme Court of the 1880s to use language like this. The world, from the perspective of the tribes, was a very different place. The government's policies were ramped up in terms of seeking the dissolution of tribal nations and their reserve lands. So the prospects for retained sovereignty were not very good in the 1880s, but this is being lifted and plopped into an opinion in 1978, the so-called era of self-determination. And the court seems to be endorsing, implicitly at least, this language that there really are only two sovereigns in this space, in this juridical space: the U.S., the federal government, and the states. So in effect, the court is again manufacturing a historical fact here that the claim to that tribes are sovereigns is not viable. It's not true. This is the case, U.S. versus Kagama from 1886. And so again, this is the opinion that the court is quoting from in 1978. And notice what the court is saying here. It's outlining and relying on this notion of dependency. That's a term that John Marshall used back in the famous Cherokee cases, where he talked about tribes being domestic dependent nations. But Marshall had a very different meaning, or attached a very different meaning to the term dependency. Marshall, in the court back in the 1830s, conceived of dependency by referencing international notions of dependency, that weaker nations could align themselves with stronger nations as a way to preserve and protect their sovereign status. And there were parallels that the court referenced to Europe, where smaller nations signed treaties with stronger nations. Think of Monaco and Liechtenstein and smaller nations like that. And yet the court here in 1886 is using dependency in a very different way, talking about tribes being dependent for their food, for their political rights, etc. They need protection, especially from the states. And from their very weakness and helplessness, largely due to the course of dealing by the federal government and the treaties in which it has been promised, there arises the duty of protection, and with it, the power. Now, if you recall that the reference in Lone Wolf to plenary power, this is where it's actually formulated. The idea that the Congress, the federal government, has this overarching, virtually unlimited power in Indian affairs. Kagama is the opinion that creates that. And it's given a name in Lone Wolf versus Hitchcock, 1903. It arises from this perception, this conception of tribes as weak and helpless, basically like juridical children. And if we go back to the Cherokee cases, Marshall did use the reference. The tribe's relations with the federal government is very much like a ward and a guardian, ward and guardian, child and parent type of relationship. And so with that duty of protection arises the power, which is given a name, plenary power. And if we move back to the 1970s and 1980s, we see that our storyteller in chief actually, not only, he meant it when he said that. Here's a passage from an oral argument held in 1981 in a different federal Indian law case, Marion versus Jicarilla Apache. And during the to and fro with the lawyers, one of the lawyers mentioned the principle of tribal sovereignty. And this is what Justice Rehnquist said in response. He interrupted the lawyer and he said, "This court has retreated from the position that Indians are sovereigns." Now just ponder that. In her introduction, Danielle reminded us that tribal sovereignty, the recognition of tribes as political bodies, is enshrined in the Constitution. Article 1 says Congress regulates commerce with the foreign nations, with the several states, and with the Indian tribes. You know, you do a Sesame Street analysis there and says, you know, which things, how are they all the same? Well, they're all political bodies. So this is quite radical in terms of a judicially produced historical fact that tribes, in fact, are not even sovereigns. Thankfully, the modern court, the majority of the modern court, does not adhere to this, but certainly Justice Rehnquist held fast to that notion and held on to that for quite some time. Here's another justice who we could have spent a lot of time talking about, the late Justice Antonin Scalia. He actually said this. In 2008, he was at a book signing where a young woman named April Yupi Roll, she was the granddaughter of a person who gave his name to one of the major federal Indian law cases, Yupi versus Babbitt. She is a granddaughter of Yupi. And she goes to the book signing and tells Justice Scalia that her grandfather was a plaintiff, a party in a major Supreme Court case. He happened to recall the case, and notice what he said to her. Well, you know, when it comes to Indian law, most of the time, we're just making it up. I'll just let you process that statement. Most of the time, we're just making it up. Well, I think I've given you a few examples where it surely does appear that the court was just making it up. Tribes as hunter-gatherers, not according to the historical record, and certainly not true for all tribes, but that's the sort of production of a historical fact. Or the idea that tribes went along with the idea that treaties could be broken unilaterally. This consent, this presumed consentience, is a historical fact. Not so much if we look at the historical record. Or this idea, the very idea that tribes have a legitimate claim to a sovereign status being contested as well into the 1970s and early 80s. So there is a lot that's being made up. The tribes obviously are not taking all of this passively. From the beginning and well into the modern era, tribes are contesting. They're active, they're pushing back, they're litigating, they're making their claims. And I want to at least close the slideshow with a couple of Minnesota references. Some of you may be aware of this, many of you may not be, but just a couple of years ago, the White Earth Band of Ojibwe, Anishinaabe people, passed a law, a tribal law, that recognized Manuman, wild rice, with having rights of legal personality. In other words, rice is a legal person in the way that a corporation is a person in the eyes of the law. Here's what some of the tribal law says. Manuman has the right to clean water and freshwater habitat, the right to a natural environment free from industrial pollution, etc. There are other indigenous societies around the world that have done similar things here under the rubric of rights of nature. These are new legal theories premised on very ancient teachings. The idea that from an indigenous perspective, natural features are not commodities or things that can be dominated or sold and parceled off. They are, in essence, they are relatives. Rivers, trees, forests, rice. So we know that the Maori in New Zealand, for example, have worked out arrangements with the government of New Zealand to accord rights of legal personality for the Whanganui River, for Mount Taranaka, for a national forest. In addition to the White Earth Band of Ojibwe, the Hupa tribe in Northern California passed a tribal law just last year, or maybe in 2019, that accords rights of legal personality to the Klamath River. Now, this is wonderful news and fascinating legal development, in part because of something that you all know is happening right now in Minnesota. A lawsuit brought by the White Earth people and the Red Lake community, Red Lake Band of Chippewa, and some nonprofit organizations, including the Sierra Club, contesting the construction of this pipeline, Enbridge 3, that would go through, the green represents unceded treaty lands. While I don't think it's been officially made a part of the complaint in this case, the right of Manuman as a party, it's really interesting to ponder the future of litigation where tribes, or at least individuals speaking on behalf of the river or trees, or in this case, the rice, would be able to join a litigation like this to say that in addition to my human relatives, I am speaking on my own behalf. I don't want to be contaminated by potential leaking tar sand oil coming from Alberta through our ancestral homeland. These people depend on me. It's just a fascinating development for us to consider. I'll stop the slideshow there and turn to one last update on the Oliphant case. I began and I will close with Oliphant. Remember the holding of Oliphant. The central holding of Oliphant was that tribal nations essentially were divested of the legal power to prosecute non-Indians. Well, in 2013, when Congress was reauthorizing the Violence Against Women Act, they included a provision that's still on the books that authorized, it affirmed and recognized the power of tribes to prosecute any person, including non-native people, for violation of a certain very short list of crimes, including domestic violence and the violation of certain protective orders. There are some 19 tribes, I believe, that I believe that's the number. Actually, no, there's nearly 30 tribes that since 2013 have adopted and taken advantage of those provisions that provide a role for tribe to essentially prosecute people committing these crimes. Right now, in 2021, just a few weeks ago, the current Congress, both the House and in the Senate, introduced legislation to reauthorize VAWA and would extend this list to add a few more crimes, including crimes of sexual violence, crimes directed at children, crimes including human trafficking. And so it would be enlarging the scope of powers that tribes would have against any person. Now, Congress, in doing this, also imposed a lot of provisions on tribes or requirements. So there's a pretty hefty price that tribes have to pay in order to exercise this authority. They have to essentially adapt their judicial system in a way that it largely mimics that of the state and federal courts in terms of the protections afforded individuals from a due process and equal protection standpoint. And that can be costly. And so for many tribes, the reason they have not taken advantage of these provisions is because they either don't have the funding or are not willing to adapt their judicial systems to suit the requirements. But it is true that to that extent, Oliphant has been partially overruled. It's still good law, but it's been modestly overruled to allow a space, to create a space for tribes to exercise some of their inherent sovereign authority to deal with the issue, the pernicious issue of violence against Native women, which was the subject of Louise's book, The Roundhouse. Thank you very much for your attention. I will stop the presentation there and turn it over to you for any questions. And I think we have at least 15 or 20 minutes or so. Danielle, is that about right?
That's right, Bruce. Thank you so much for that incredibly illuminating lecture. Appreciate it. We do have some questions in the Q&A, but I do want to give people a chance to think some more about that. So one of the questions that comes to mind for me is that given all of the different ways that the American system has attempted to erode sovereignty, what are, and that the court is, in the words of Audre Lorde, the tools of the master's house. How have the tribal nations asserted their inherent sovereignty? What are some of the different ways?
There are a number of ways. One is that they have tribal leaders have become quite skilled at working effectively to lobby Congress to pass certain laws. So the modern day Congress has actually been quite responsive. So they have looked to Congress and challenged Congress to utilize its constitutional authority to reassert itself in the sphere of federal tribal relations. In other words, don't defer to the courts to let them dictate the shape and contour of this very important relationship. And so the Congress has actually been quite amazingly supportive in certain areas, in certain ways. In the judicial sphere, I think that responding or contesting what the court has or is doing is much harder. And the reason it's harder is that there's no real way to prevent the court doing what I described, what it was doing in the Oliphant case. And so I think part of the strategy there is highlighting and illuminating for the court when it is reprising these old 19th century precedents, is to call those out, to expose them for the falsities that they contain, and to say, look, you can't just cite Johnson against McIntosh and expect us not to push back, because what you're doing in effect is reifying some very, very racist conceptions that certainly served your purposes, your being the colonial or imperialist purposes of the US government, but in the modern era simply have no place. And so I think the scholarship has certainly done this, litigants are certainly doing this. And I have to say, people like Louise Erdrich, humanists, artists, writers, Indigenous writers around the world have joined in to lend their voices to calling out these judicial constructions to say, you know, we're watching you. We're watching how you're framing these arguments, and we're just not going to give you a pass, you know, to just sort of blink, blink, nod, nod, and we'll cite to Lone Wolf, we'll cite to Kagama, because we know it's sort of like the Wizard of Oz. You know, we've pulled the curtain back and we see who's controlling that figure up there, and it's just this guy, you know, and trying to perpetuate and preserve his claim to power. And so I think that the multifold strategy there is sort of what I would point to.
Okay, and that actually leads to Dick Todd's question. Are there additional legislative remedies you would recommend to correct the bad, quote unquote, bad law of the Supreme Court?
Yes, and so in Shadow Nations, I go big in the sense of saying, look, we can either do this issue by issue, you know, criminal jurisdiction, taxation, environmentalism, you know, but that would take us another, you know, 10 generations to do it that way. But that's actually being handled. The argument that I make in Shadow Nations is that we need to engage in what I call another round of nation rebuilding. And I call for conventions of tribal sovereignty, that there should be a master treaty, not the sort of one treaty per tribe from the 19th century, but rather a new document that lays out what are the foundational principles by which the tribal nations and the federal government will relate to each other. And it would be sort of the meta text by which we can put down and let me just use criminal law, for example. The provisions of this master treaty would say that it would recognize the tribe's power to prosecute any wrongdoer who commits a crime within the tribe's lands. That's an uncontroversial proposition. If I go to Canada, I cannot say, well, I'm not a Canadian citizen, so therefore Canada cannot enforce its criminal laws against me. No country adheres to that rule because of the principle of territorial sovereignty. When you are on the territory of another sovereign, you are subject to their laws. That principle doesn't apply to tribal nations, thanks to Oliphant. So in this master treaty, what it could do is to say tribes are part of this architecture of power that respects the principle of territorial sovereignty. Now, the way that, how to operationalize that, we know that the US and the states use the Bill of Rights and the Constitution. The tribes have their own ways that might be as good, if not better sometimes. So they could talk about ways to say, what's the common ground? How do we want to align our respective interests here, instead of just simply doing what Oliphant did, which is to say, we don't trust you. We don't want tribes to prosecute white people. That's a reversal of the whole colonial cycle. And we can't tolerate that form of robust sovereignty. So we want to keep tribes in their little sovereignty sandboxes, where the US purports to have the power to create a little sandbox, and the tribes can be as sovereign as they want, as long as they stay in their sandbox. Well, tribes are not content with that. And that's certainly a very retrograde view. It's a very poverty-based view of tribal sovereignty. So there are a multitude of ways. That's a big way to go with it, is to kind of do a nation rebuilding exercise.
Okay, so we have some really good questions here. Paul asks, independent of the rights of nature, do treaty rights give tribes solid legal grounds to resist pipelines?
Yes and no. The yes part is if the pipelines are on the tribe's own lands. In other words, the lands that are still considered part of the reservation. Or on which there may be off-reservation treaty rights. So in other words, the reservation may have contracted over time because other parcels of the reservation have been surrendered, but there may have been a reserve clause that says, but we reserve the right to hunt and fish and gather in certain sites. Those are protected property rights. And so to that extent, even though that's an off-reservation right, it is enshrined in the treaty. That is a form of property right that the modern Supreme Court respects, and that would give the tribe leverage to say, you cannot run this pipeline consistent with the threat to our ability to exercise these still extant treaty rights.
And there's a follow-up related question from Meg. Given the current leanings toward originality or originalism in many district and Supreme Court, is there any possibility that legal challenges to nature rights will have much chance of making progress?
I don't know. That's a great question. I thought where the questioner was going was with the newly constituted Supreme Court with Judge Amy Barrett there. I don't know. There's not much that I know about her judicial philosophy, but even as an originalist, one could make the argument that you would expect tribal claims to fare well in this kind of court that puts a lot of stock in originalism or textualism, to say, what was the founder's purpose? Well, if we really went back to the founder's purpose, we would be reifying the concept of a robust legal pluralism. The idea that the federal government doesn't have plenary power, that's a fiction. It never had plenary power. The tribes never agreed to the federal government having carte blanche to dictate the terms for how to conduct this relationship. They were meant to be bilateral, truly bilateral. And as the court itself has pointed out, treaties are the only constitutionally sanctioned means by which this relationship is to take place. So if we want to go back to the beginning, I would say, let's go there, because then we'd have to be very honest about what the text of the Constitution actually says. And there is nothing in the Constitution about plenary power or plenary anything. We would have to respect the integrity of tribes as recognized sovereigns in very much the same way that foreign nations and the states are recognized as sovereigns with whom the federal government conducts relations.
Here's a question from Maureen. How would a master or unilateral treaty impact existing treaties, land treaties?
Yep. So I would think they would have to be preserved, and there should be an express provision that would say extant treaties are preserved. You wouldn't eradicate that. And in fact, when Congress legislated unilaterally in 1871 to end treaty making, that statute explicitly said all existing treaties are preserved. So it didn't abrogate those other treaties. It just said, from this point forward, no more treaties. So this master treaty or mega treaty would have to do something similar to that.
Okay. Trying to track questions in different places. Here we go. Okay, so somebody, Jane has a question about the McGirt case. Can you describe the impact of that case in terms of how, like, what its implications are for the tribal nations in other parts of North America?
Well, that's certainly been the topic of a lot of discussions ever since last July. The state of Oklahoma has designated a group of folks who are meeting with different tribal nations. They come together, sometimes separately, and are talking about the implications of this decision. And it goes far beyond just who has criminal jurisdiction to prosecute individuals. It has implications for tax policy. It has implications. I mean, think about it. If you've been paying property taxes to the state, and lo and behold, the reservation is still existing. Those boundaries still exist. The county or the city of Tulsa or the state itself may have no credible basis for saying their powers to tax are still preserved, if they don't have the power to prosecute. So there are lots of implications, but the Supreme Court, during the oral argument in the McGirt case, heard those concerns. The various parties, including the state of Oklahoma, was basically saying, the sky is going to fall if you decide this in favor of the Muskogee Creek, because it's going to create chaos. And the response from the tribe and the allies, the friends of the court who join on the tribal side, they said, look at places like Tacoma, Washington. Tacoma is still has a lot of Indian country lands surrounding it and including it. And yet they have worked out relations. They have managed to work out and sort out this sort of bilateral authority on a host of issues, including who's going to pick up the trash. Like, is it tribal? Is that a tribal matter? Is that a state or county matter? Folks can be grown up about this and come together and still formulate. So that's what they're doing, is issue by issue, media by media, whether it's taxation policy, environmental regulation, criminal jurisdiction, taxation, these are all being discussed anew today. Here at Dartmouth, we're in a few weeks, we'll have the principal chief of the Shawnee tribe coming to talk to our community to give us a sort of a view from the ground of how are the Shawnee approaching this, give us a perspective of what's actually going on and see how those conversations are going. So we're anxious to hear from him. We're also going to hear from, I just confirmed this yesterday, so I'm excited, but one of my former students was recently named a few weeks ago. Pauwi Rivera is the White House Director of Tribal Affairs. He's from the Pueblo of Pewaukee. He's going to be joining us in mid-April to give us a view from the sort of national level about, the Indian affairs in the Biden era or something like that. And so we're very, very keen to educate our community about the current status of cases like McGirt and the current direction of national politics and policy in Indian affairs moving forward.
Okay, and I think I'm going to take one more question. This one is from Taylor. How do you think I love it when people, it always happens, somebody wants a historian to predict the future because We want to know what's going to come next. How do you think the Court of Appeals might rule on the challenges to the Enbridge Line 3, and what might the implications be of that?
Well, I should say I'm a member of the Board of Trustees of Earth Justice, and so that organization has taken, they're representing the White Earth tribe in that case. They're also continue to represent Standing Rock on the DAPO case. If we look at, the facts of the case, there's some substantial worries that the Army Corps of Engineers did not do the proper kind of environmental impact assessment that was required. So if we start from first propositions that if they're following the law, at least this is what our lawyers are arguing, this permit should never have been approved. So that's what I would hope for, but I don't know if that's the way it's going to unfold. The other hope is that, like the president did with DAPL, that they might use the power of the presidency to yank permits in the Enbridge cases as well, because there's also the Enbridge 5 going through Michigan, where Earth Justice is representing the Bay Mills community there on that litigation. And so, yeah, there's quite a lot of activity happening in the world of pipelines. And of course, that means that we are continuing to attach ourselves to fossil fuels. And those of you, the audience, who watched the hearings confirming Deb Haaland as the next Secretary of Interior, we know that a major plank of the new administration is to wean us off of fossil fuels and to put us on a path for a new economy focused on renewables. And I can imagine, I know that tribes should be playing a major role in energy production that is tied to renewables, be it wind, solar, et cetera. And that's where living on the northern prairies could become a positive factor, because they're some of the highest wind-rich states, areas in the country. Of course, the challenge is getting that power to market. So there's a lot of moving pieces when we look at the implications of those cases.
Right. Thank you again, Bruce. This was incredibly interesting, and I think everybody's going to walk away with a lot to think about. I just wanted to point people out to the chat. If you are interested in finding out more about Native governance and tribal sovereignty in Minnesota, check out the Native Governance Center. It's a great place to start. I put the link to their website in the chat. And also, I want to invite you to come back and join us again. We have 2 programs coming up in April. One on April 6th, a special lecture about the history of the Equal Rights Amendment, which is coming up on its 100th birthday. It's making its way through Congress again, so it's back in the news. And then April 20th, we'll have our final History Forum lecture with Steve Kahn from Miami University, talking about the roots of the rural-urban divide in American politics. So hopefully you'll join us again. Thanks for coming, everybody.